We'll hear argument this morning in Case 14-11-4, King v. Burwell. Mr. Carvin.
Mr. Chief Justice, and may it please the Court, this is a straightforward case of statutory construction where the plain language of the statute dictates the result.
Mr. Carvin, will you please back up, because before we get to a question of statutory construction, as you know, each plaintiff, or at least one plaintiff, has to have a concrete stake in these questions. They can't put them as ideological questions. And we have four plaintiffs. As to two of them, there is a declaration stating, I am not eligible for health insurance from the government, but there's a question of whether they are veterans eligible for coverage as veterans.
Yes, one of those is Mr. Hurst, who would have to, if I would refer you to the joint appendix at page 42, where this is the government's recitation of facts, where they make it clear that Mr. Hurst would have to spend $750 of his own money because of the IRS rule. Mr. Hurst was a veteran for 10 months in 1970. He is not eligible for any veterans service because if you've served such a short health services, if you've served such...
I'll ask the government if they agree that...
And I should point out that the government has never disputed this, and I'd also...
But the court has an obligation to look into it on its own.
That's true, but of course there has been fact-finding by lower courts in an adversarial system. I don't believe the court does its own.
I don't think it was ever brought up in the lower court that these two people were veterans. If
I could make one further point on this, Justice Ginsburg, even if he were technically eligible, which he is not, there's a IRS rule 26 CFR 1.36b 2CII, which says you will,
yes,
with the usual clarity of the IRS code, making clear that you are only disabled from receiving subsidies if you have actually enrolled in a Veterans Health Services, and it's undisputed that Mr. Hurst
if that's their position too. And then there were the two women. I think one of them was going to turn 65 in June, which would make her Medicaid eligible.
She will turn 65 in late June. She's obviously subject to the individual mandate well in advance of that. By virtue of the IRS rule, she would have to spend $1,800 per year for health insurance by virtue of the IRS. Excuse me?
But you said she will turn 65 in June.
Late June, yes.
So that takes care of 2015.
No. Right now, she is obliged under the individual mandate to have insurance. You have to have insurance for 9 months of the year. And so as of April 1st, she will be subject to the penalty, which will be alleviated only by...
Again, I'll ask the government if they agree with you on that. And then I think for the fourth plaintiff, there's a question whether she would qualify for a hardship exemption from the individual mandate, even if she received the tax credit, in which case the tax credits would be irrelevant.
That's true. Again, I'll refer you to the joint appendix at 41. That was the government's argument below. We didn't want to get into a factual dispute about it because we had such clear standing with respect
but you would have to establish the standing, prove the standing, if this gets beyond the opening door.
Fair enough, Your Honor, but it's black-letter law that only one plaintiff needs standing, and for the reasons I've already articulated, both Plaintiff Hurst and Plaintiff Levy have.
I don't want to detain you on this anymore, but I will ask the government what their position is on standing.
Thank you. Returning to the merits, the only provision in the Act which either authorizes or limits subsidies says in plain English that the subsidies are only available through an exchange established by the state under Section 1311.
If you're going to elaborate on that, I would appreciate in your elaboration. I've read that, and this statute is like the tax code more than it's like the Constitution. There are defined terms, and the words you just used concern a defined term. Now, as I read the definition, there's a section, definitions, and it says, quote, the term exchange means, quote, an exchange established under 1311, and 1311 says an exchange shall be a government agency, etc., that is established by a state. Those are the definitions. So then you look to 1321. And 1321 says, if a state does not set up that exchange, then the federal, quote, secretary shall establish and operate such exchange. So it says the secretary is to establish and operate such exchange, the only kind of exchange to which the Act refers, which is quote, an exchange established by a state under 1311. That's the definition. So the statute tells the secretary, set up such exchange, namely a 1311 state exchange. Correct. And there's nothing else in this statute.
Correct.
So that's throughout what they're talking about. And so what's the problem?
As Your Honor just said, it tells the secretary to establish such exchange.
Yes.
And what 36B turns on is whether the state or the secretary has established
No,
such
it uses the same terminology that it's used in 15 times in this statute, namely the terminology in the definition is an exchange established by a state. That's the phrase.
Well, under 1311, that is the phrase. And if 1311 created the definitional section created some ambiguity as to whether HHS was establishing a 1311 or 1321 exchange, that is immaterial, because 36B does not say all 1311 exchanges get subsidies. It says exchanges established by the state under Section 1311, not established by HHS under Section 1311. So it eliminates any potential ambiguity created by the definitional section.
Can I offer you a sort of simple daily life kind of example, which I think is linguistically equivalent to what the sections here say that Justice Breyer was talking about? So I have 3 clerks, Mr. Carvin. Their names are Will and Elizabeth and Amanda, okay? So my first clerk, I say, Will, I'd like you to write me a memo. And I say, Elizabeth, I want you to edit Will's memo once he's done. And then I say, Amanda, listen, if Will is too busy to write the memo, I want you to write such memo. Now my question is, if Will is too busy to write the memo and Amanda has to write such memo, should Elizabeth edit the memo?
If you are going to create monies to Will for writing the memo, and Amanda writes the memo, and you say the money will go if Will writes the memo, then under plain English and common sense, no. When Amanda writes the memo,
you run a different shop than I do, if that's the way. Because in my chambers, if Elizabeth did not edit the memo, Elizabeth would not be performing her function. In other words, there's a substitute, and I've set up a substitute, and then I've given instructions. Elizabeth, you edit Will's memo, but of course if Amanda writes the memo, the instructions carry over. Elizabeth knows what she's supposed to do. She's supposed to edit Amanda's memo too.
And in your chambers, you're agnostic as to whether Will, Elizabeth, or Amanda writes it. But the key point here is under Section 1311, Congress was not agnostic as to whether states or HHS established the exchange.
Well, Mr. Carvin, if I had those clerks, the same clerks, and Amanda wrote the memo, and I received it, and I said, this is a great memo. Who wrote it? Would the answer be it was written by Will because Amanda stepped into Will's shoes?
That was my first answer. Justice Kagan didn't accept it, so I'm going to the second answer, which is you are agnostic as between Will and Amanda, but Congress was not agnostic as between state and federal exchange.
That's a very important point, I think, because what you're saying is that the answer to the question really does depend on context. And it depends on an understanding of the law as a whole and whether they were agnostic. I agree with that. So it's not the simple 4 or 5 words. Because the 4 or 5 words in my example, it's obvious that Elizabeth should edit the memo. It's the whole structure and context of the provision that suggests whether those instructions carry over to the substitute, isn't it?
We implore you to examine these words in the context of the Act as a whole, because our argument becomes stronger for 5 reasons. To respond to Justice Breyer's point, he says such exchange connotes that it's the same person doing it. But look at the provision on territorial exchanges. It says territories can establish such exchanges, and then it says, and shall be treated as a state.
Yes, it does, but you say connote. No, it's not a question of connotation. It is a question of denotation. Now, what does that mean? It means that the federal government, the secretary, is establishing a thing for the state. And what is the thing? The thing that it is establishing for the state is defined as an exchange established by the state. Now, that a person from Mars who's literal, which I usually am not, but a literalist, well, I think would have to read it that way. But if you're not a literalist, well, at least you could read it that way. Now, you want to go into the context. If you want to go into the context, at that point it seems to me your argument really is weaker. The exchanges fall apart. Nobody can buy anything on them. You know the arguments. You've read the briefs. There are no customers. Employers don't have to pay penalties as long as they use just people from Virginia, but one Maryland person comes. You know all those arguments. So how does the context support you?
Well, again, under the literalist or non-literalist interpretation, saying that HHS will establish such exchange doesn't suggest that the state has established such exchange. If there was ambiguity in that regard, just if I could finish my answer to Justice Breyer, you look at a parallel provision where they used precisely the same language, and they said, and shall be treated as a state. That language which is notably omitted from 1321, and it's a basic principle of statutory construction that you interpret the same phrases the same way, and it shows that Congress knew how to create equivalence between non-state exchanges and exchanges if and when it wanted to. Sorry, Justice Sotomayor.
Take a breath. I'm a little concerned with how you envision this provision working. You're saying that the HHS exchange can't be for the state, so that it's established by the choice of the state. The choice the state had was establish your own exchange or let the federal government establish it for you. That was the choice. If we read it the way you're saying, then we're going to read a statute as intruding on the federal-state relationship, because then the states are going to be coerced into establishing their own exchanges. And you say, oh, no, they can't be coerced. But let's go back to what Justice Breyer was talking about. In those states that their citizens don't receive subsidies, we're going to have the death spiral that this system was created to avoid. States are obligated, insurers are obligated, to make sure that in their states, whether they're part of this program or not, that they have guaranteed coverage, that children are covered till they're 26, and that they base their costs on community ratings. So if they have to do that, then costs are going to rise on every insurance plan offered in the country in those 34 states. 3 or 6 or 9 of your states will have tightened their Medicaid eligibility requirements in contravention of the Act. So they're taking money by breaking their compacts. They would have to lose all of their Medicaid money. Tell me how that is not coercive in an unconstitutional way. And if it is coercive in an unconstitutional way, in Bond, I think it was last term, we said that that is a primary statutory command, that we read a statute in a way where we don't impinge on the basic federal-state relationship.
This Court has never suggested, outside the very unusual coercion context of the NFIB Medicaid, that a funding condition somehow invades a state police power. Obviously,
well, we did it. We said it last year.
In in Bond, there the federal government was taking away a police power. Here, all the federal government's doing is saying, "You want billions of free federal dollars." That's hardly invading state sovereignty, and it's the kind of routine funding condition that this Court has upheld countless times.
Let me say that from the standpoint of the dynamics of federalism, it does seem to me that there's something very powerful to the point that if your argument is accepted, the states are being told either create your own exchange or we'll send your insurance market into a death spiral. We'll have people pay mandated taxes, which will not get any credit on the subsidies. Cost of insurance will be sky high, but this is not coercion. It seems to me that under your argument, perhaps you will prevail in the plain words of the statute. There's a serious constitutional problem if we adopt your argument.
2 points, Justice Kennedy. One is the government's never made that argument. Number two, I don't think...
Sometimes we think of things the government doesn't.
Well, I certainly hope you do in this case, but not on this question. But what I'm trying to, quite seriously, Justice Kennedy, is convey is, if this was unconstitutional, then the Medicaid statute that this Court approved in NFIB would be unconstitutional.
Carvin, what would the consequence of unconstitutionality be? Very often you have an ambiguous provision, could be interpreted one way or another way. If interpreting it one way is unconstitutional, you interpret it the other way.
Correct.
But do we have any case which says that when there is a clear provision, if it is unconstitutional, we can rewrite it?
And that's really,
is there any case we have that says that?
No, Your Honor. And that was really my point, Justice Kennedy. Think about the consequences when of the Medicaid deal as being coercive. 22 states have said no to the Medicaid deal. That has created a bizarre anomaly in the law, that if people making less than the poverty line are not available to any federal funds to help them with health insurance.
I fully understand that, but I think the Court and the Council for both sides should confront the proposition that your argument raises a serious constitutional question. Now, I'm not sure that the government would agree with that, but it is in the background of how we interpret this statute. It may well be that you're correct as to these words, and there's nothing we can do. I understand that.
There are many...
there's no savings construction, to echo Justice Scalia's point, but B, the point I want to make on the straight-up constitutionality is, if this is unconstitutional, then all of the provisions in the U.S. Code that say to states, if you do something for No Child Left Behind, we will cut you off.
I'm sure in South Carolina versus Dole, where there was a matter of funding for the highway, suppose Congress said, and if you don't build the highways, you have to go 35 miles an hour all over the state. We wouldn't allow that.
No. Well, there, of course, you would be interfering with a basic state prerogative as to establish their limits, and the condition is not related to that. Here, the condition is perfectly related to it.
Mr. Carvin,
we want to create something new.
Mr. Carvin, you referred to the Medicaid example. That's a grant and aid says to the state, here's the federal money, and here's the conditions, take it or leave it. That's one pattern. But this pattern that we have says flexible state. You can have your program if you want it, and if you don't, there's a fallback. There's the federal program. I mean, that's a typical pattern. It's the pattern of the Clean Air Act. You can have a state implementation plan, but state, if you don't get up your plan, there's a federal implementation plan. But I have never seen anything like this, where it's, if you take what the statute says you can have in 1321, then you get these disastrous consequences.
That's why this is much less risky a deal for Congress, and what distinguishes it from Medicaid, as the dissenting opinion in NFIB pointed out. In Medicaid, Congress is playing all in, take it or leave it. If they turn down the deal, then Medicaid is completely thwarted. Here, if they turn down the subsidy deal, they still get the valuable benefits of an exchange. And there's not a scintilla of...
What are those benefits? What are the customers that can buy on it? What are the insurers that will sell on it?
Well, 3 points. One is we know textually that they thought exchanges without subsidies work because, again, they have territorial exchanges, but the government concedes no subsidies.
That's not
we have
what,
legislative
Carvin,
history.
That's not what you said previously. When you were here last time in this never-ending saga, you said without the subsidies driving demand within the exchanges, insurance companies would have absolutely no reason to offer their products through exchanges. And then you said the insurance exchanges cannot operate as intended by Congress absent the subsidies.
That is entirely true. They wouldn't have operated as intended because Congress intended all 50 states to take this deal. So
why create 1326 at all? Obviously, they thought that some states wouldn't.
Well, they thought it was possible.
Oh, very possible, because they set up a mechanism for that to happen.
And then what happens? You still get the exchange. It's not like Medicaid where the entire federal program is thwarted. You get the benefits that were lauded.
No one's going to visit the program if there are no subsidies because not enough people will buy the programs to stay in the exchanges.
That is demonstrably untrue and not reflected anywhere in the legislative history. The legislative history quite clearly contradicts that. Many senators got up and said there are very valuable benefits to the exchange, one-stop shopping, Amazon, as President Obama has said. The government came in the last case and told you these two things operate quite independently. We don't need exchange without subsidies. In contrast, there's not a scintilla of legislative history suggesting that without subsidies, there will be a death spiral. Not a word.
Wait a minute. That was the whole purpose that drove this bill, because states had experimented with this, and those that didn't have subsidies or other provisions of the Act didn't survive.
They didn't have.
You said it yourself in the prior case.
No. The prior case was about the individual mandate. The government came in and said the individual mandate is necessary to affect death spirals. No one in the findings in Congress or anywhere else suggested that subsidies were available. Will subsidies reduce the number of people available?
My problem is that the reverse. You're talking about Congress hiding, borrowing the phrase of one of my colleagues, a huge thing in a mousetrap. Okay? Because do you really believe that states fully understood that they were not going to get — their citizens were not going to get subsidies if they let the federal government? What senator said that during the hearing?
The same amount of senators who said that subsidies were available on HHS exchanges, which is none. They didn't deal with it in the legislative history, just as they didn't deal with Medicaid, because the statute was quite clear. Let's talk about a context again, Justice Sotomayor. The context is the only provisions in the Act establishing any limits on the subsidies is found in 36B. So it's not a mouse hole, it's the place you'd expect to find it. It's the only place in the Act that limits subsidies to purchases made on it.
Well, I don't think that's quite right, Mr.
Justice Ginsburg.
It's a tax code provision. It's an implementation provision. It tells you how you compute the individual amount. It's not in the body of the legislation where you would expect to find this.
No, Your Honor, if that's
what Justice Kagan just read to you, you had the idea that the subsidies were essential to have the thing work. That's what you told us last time.
What I told you was it wouldn't work as expected. And that's because they thought this deal would work just like the Medicaid deal, where all 50 states would say yes, so you would have both of congressional
purposes. Why would they set up this whole extra thing if they didn't think anybody was going to take it?
Well, that was my response to Justice Sotomayor. That is a completely unsupported empirical observation made post hoc by amicus. There's no reflection of that in the legislative history. Indeed, the legislative history refutes it.
Mr. Carvin, we've heard talk about this other case. Did you win that other case? So maybe it makes sense that you have a different story today?
I'm really glad Your Honor said that. And if I could return to context.
I mean, I'm sorry, Mr. Carvin, please.
Just very briefly, Justice Kagan, very much appreciated. To respond, we've already talked about the context. Section 1311 is a key part of this context. It says in the strongest possible terms we want states to run these exchanges. If you give unconditional subsidies, then of course there is absolutely no incentive for states to do it, and you have fundamentally undermined that distinct statutory purpose. Whereas if you condition subsidies, Congress accomplishes both of its goals. Widespread subsidies plus state-run exchanges. In terms of art, again, there is language in the statute which says exchanges under the Act. Those phrases naturally encompass both HHS exchanges and state-established exchanges. And yet the Solicitor General is coming here to tell you that a rational English-speaking person intending to convey subsidies available on HHS exchanges use the phrase exchanges established by the state. He cannot provide to you any rational reason why somebody trying to convey the former would use the latter formulation.
Mr. Carvin, why don't you take an extra 10 minutes, and maybe we'll give you a little bit more of a chance to talk.
Okay. Fine.
Well, then I'll ask a question.
Well, if you're going to ruin my 10 minutes.
No, I mean, let's go back to this question of where Congress put this thing. Because putting aside constitutional issues, I mean, there's at least a presumption as we interpret statutes that Congress does not mean to impose heavy burdens and draconian choices on states unless it says so awfully clearly. And here, and this goes back to what Justice Ginsburg was saying, there's really nothing clear about this. I mean, this took a year and a half for anybody to even notice this language. And as Justice Ginsburg said, it's put in not in the place that you would expect it to be put in, which is where it says to the states, here's the choice you have. It's not even put in where the statute defines who a qualified individual is or who's entitled to get the subsidies. Rather, it comes in this technical formula that's directed to the Department of the Treasury saying how much the amount of the subsidy should be. And that seems to be it both makes no sense from Congress's point of view, and in terms of our own point of view, in terms of interpreting statutes, that's not the clarity with which we require the government to speak when it's upsetting federal-state relations like this.
I must respectfully disagree for three reasons, Justice Kagan. In the first place, of course, where else would you expect a tax credit except in the tax code? That's where this was. You wouldn't put it in 42 U.S.C., which has nothing to do with taxes. It's the only place where exchange limitation is placed. You have three audiences here, not just states. You have to tell taxpayers what they're entitled to. You have to tell insurance companies when these subsidies are available, and you have states. So you have to put it in 36B. So the argument I guess the government is making is what you should have done is put half of it in 36B and half of it in 1321, which of course would have confused everybody. 36B would say exchanges period. Then you'd go to 1321 and say, when we said exchanges in 36B, we meant established by the state.
If I were a state official and I was trying to decide whether my state should establish an exchange, and I wanted to know whether individuals who enrolled in a plan on my possible state-established exchange would get a credit, where would I look?
Exactly. The basic thesis here is these exchanges don't work without subsidies. You've read 1311, you've read 1321, now you're going to go find out where the subsidies are. That's 36B. They're hypothesizing
I think not, Mr. Carvin. I mean, I think the place I would look to find out about my choices is in the provision of the statute that talks about my choices. I think the last place I would look is a provision of the statute that talks about, coverage months for purposes of this subsection, which, by the way, isn't even the right subsection, but whatever. That's where I would look, is in where it talks about what a coverage month is.
But, Your Honor, I've already described the difficulties of putting in part of it in 1321, right? Because then you would create this bizarre tax credit provision, which is only half true, and you wouldn't tell taxpayers and insurance companies. So I believe that's the complete answer. But the other practical point I'd like to make is they had 3 years to implement this. No one thought the states were going to have to make a decision overnight. If the IRS had done its job, every state would have been fully informed of the consequences because presumably they've read 36B, and then they would make an intelligent decision well in advance of the 2013 deadline. So this bizarre notion that states were somehow unable to read a statute or to read a regulation is simply not valid.
I really want to hear what you're going to say in your 5 to 10 minutes. And if you want, only if you want, I would be interested in your responses to the government's brief that if you read the words established by the state without reference to the technical definition, as you wish, this isn't just about the taxes. It means employers in Virginia don't have to make policy, don't have to give policies, but if they have one Maryland worker, they do. It means that they never can tighten up their Medicaid regulations, never, in 34 states, but of course in the others they can. It means that there's no qualified person ever to buy anything on an exchange established by the Secretary for the state, and they have 2 or 3 other anomalies that have nothing to do with taxes, all of which supports their argument that you have to read this phrase technically according to the definition. Now, that's their basic point. I tried to summarize it. Do it as you wish. I just want you to have 5 or 10 minutes to answer it.
Thank you. And the first point is there are no anomalies.
I'm going to clock that. See if you get 5.
The first point I'd like to make is there's no anomaly stemming from our interpretation of 36B. The government agrees with that. Their biggest anomaly is this qualified individual's point about how there would be nobody on HHS exchanges. The Solicitor General is not going to stand up here and tell you that if we prevail on our interpretation of 36B, they will be obliged by the logic of that opinion to empty out HHS exchanges. So we all agree that there's no connection between 36B and the qualified individual. That's point 1. Point 2 is, if you want anomalies, their interpretation of the statute requires 34 states today to lose all Medicaid coverage. Why is that? Because of the provisions on 64A through 66A of the government's brief. There are various requirements that the state, on pain of losing all of its Medicaid funds, must coordinate between the state-established exchange, the state agency for CHIP, and the state agency for Medicaid in terms of secure interface and enrollment. Now, that makes perfect sense if exchange established by the state means what it says, but they think it encompasses HHS exchanges. Well, the state cannot ensure coordination between HHS exchanges and the state agencies, and none of the 34 are doing it today. So under their atextual reading of the statute, 34 states will suffer the penalty that this Court found in NFIB is unconstitutionally coercive. As to this Medicaid maintenance anomaly, the government agrees that the purpose of this provision was to freeze Medicaid payments until you had an exchange with subsidies, which makes sense, right? You want to coordinate the two. And that's exactly what this provision means under our interpretation. Until you have an exchange with subsidies, the states will be frozen. The government says that thing ended on January 1, 2014. That's a figment of their imagination. It's nowhere in the statute, plus which it makes no sense. Before 2014, the states were powerless to have an exchange with subsidies, right? They couldn't do it. So there was a 3-year freeze on Medicaid that they were powerless to get out of. After 2014, if they don't want to have their Medicaid frozen, all they have to do is establish an exchange. So it's a less harsh restriction on states, plus which it gives them another incentive, in addition to the subsidies, to create the state exchange, which is the purpose enunciated in 1311. I don't know. Maybe somebody would from another, if you had an employee that lived in another state, maybe he would be subject to the employer mandate. Why is that an anomaly? Congress liked the employer mandate. Of course they wanted to expand it. They also never thought it would really happen because, again, what they thought was going to happen was there wouldn't be neighboring states without it because nobody was going to turn down this extraordinarily generous deal. I don't know if my 5 minutes are up, but that's my response to these anomalies. I think —
As I understand — Wow, you've been talking a long time.
Sorry.
You have 2 more sentences.
Even if there were anomalies in these other sections, you don't transport them to 36B, which is concededly neither absurd and furthers the purposes of the Act. Just like in utility air, because the word pollutants didn't work with one section, you don't spread it like a virus throughout the rest of the Act. You clear it in that provision.
Those were 2
if and when there's any litigation. So
I think it
was a long sentence.
Yes. I think I'm right that Justice Breyer's question about anomalies, which are replete in the Act under your interpretation, did not talk about what I think is one of the most glaring ones, which is this qualified individuals thing, that you're essentially setting up a system in which these federal exchanges, that there will be no customers and, in fact, there will be no products, because Section 1311 says that the exchange shall make health plans available to qualified individuals, and then the next section says that qualified individual means an individual who resides in the state that established the exchange. So under your theory, if federal exchanges don't qualify as exchanges established by the state, that means federal exchanges have no customers.
Which, of course, is not the reading that the government's giving to it, because they're not going to tell you.
Well, but that's because they don't share your theory. Under your theory, that's the result.
Oh, no, let me be as clear as I can. If we prevail in this case, they are not going to empty out the HHS exchanges because they understand that there are numerous defenses, even if you interpret established by the state literally in the qualified individuals provision. Number one defense that they will use is it says you have to be a qualified individual with respect to an exchange. As Justice Breyer pointed out, the statutory definition of exchange is a 1311 exchange. So they're only talking about state exchanges, not these HHS exchanges, and it is in Section 1312, which immediately follows 1311 before 1321. Number two, qualified individual doesn't mean that means you're guaranteed access. It doesn't mean if you're not qualified, you're absolutely denied access. We know that from the illegal alien provision, which says illegal aliens are neither qualified individuals nor eligible for subsidies.
But look at the prisoner provision, which says prisoners shouldn't be treated as qualified individuals. So under your theory, this statute effectively said that prisoners should be able to enroll on federal exchanges? That makes no sense.
It makes perfect sense to say the states get a choice. Think about somebody who's in prison in February. They're getting out in April. They got to buy insurance under the individual mandate. So if you said nobody who's incarcerated can buy insurance, that means they wouldn't be able to buy insurance during the relevant enrollment period. It makes perfect sense to give states the flexibility to say, as to those incarcerated principles, you can make them available for exchanges, but under illegal aliens we don't want to, which is why we are saying they are neither qualified nor eligible. Even if you don't find that the most pristine logic to be applied to a statute, remember, we are interpreting the statute to avoid an absurd result. And it's a basic principle of statutory construction that you will give a plausible, if not the most persuasive reading to a statute to avoid the result.
But we are interpreting a statute generally to make it make sense as a whole, right? We look at the whole text. We don't look at 4 words. We look at the whole text, the particular context, the more general context, try to make everything harmonious with everything else. I think you said, even at the very beginning of this argument, as we were going back and forth about my hypothetical, that of course context matters, and context might make all the difference with respect to what those 5 words mean. And I think what we're suggesting is that if you look at the entire text, it's pretty clear that you oughtn't to treat those 5 words in the way you are.
I've given you the contextual points before. I think the key one that I'd like to convey to you, Justice Kagan, is Section 1311. You say the statute must work harmoniously. If you provide subsidies to HHS exchanges, you have essentially gutted Section 1311's strong preference for state exchanges. What will happen is precisely what did happen under the IRS rule. 2/3 of the state are saying, no, we're not going to undertake this thankless task of running these exchanges with no incentives to do so. So, yes, what I have here in terms of what the statute means is 36B quite clearly saying exchanges are available only on states. I have 1311 explaining why they limited subsidies to that, and there is no contrary legislative history at all. What do they have? An atextual reading of 36B, which they can't explain why anybody would have used those words if they wanted to convey as exchanges, a rule that completely undermines the purposes of 1311, and no supporting legislative history. So under all the legal materials that this Court normally used to discern what statute means, we clearly prevail.
Thank you, counsel.